Kosovo Specialist Chambers is now in session.
Be seated. Mr. Court Officer, please call the case.
Good morning, Your Honors. This is the file number case CBC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi. Thank you, Your Honors.
Good morning and welcome, everyone. I note that the accused are all present in court. Today we will continue hearing the closing statements in this case. First, we will continue with the Specialist Prosecutor's Office closing statements, which should be finished at about the lunch break. After lunch, we will hear from Victims' Counsel. We will follow the agenda set out in the panel's order on the closing statement, which is filing F03639. As a reminder, today's hearing is scheduled to conclude at 16:45, and breaks are scheduled for half an hour at 10:30, resuming at 11, 1.5 hours for lunch at 12, resuming at 1:30, and 15 minutes at 1500, resuming at 15:15. Lastly, since the closing statements are being interpreted, the panel reminds the parties and participants to speak at a slow pace to allow for the interpreters to catch up. This concludes the remarks from the panel. We will continue with the closing statements of the Specialist Prosecutor's Office. SPO, you've been allocated 8 hours and have 2.5 hours left, which means you are scheduled to finish by noon today. Please proceed.
Thank you. Good morning, Your Honors. We've been talking about individual criminal responsibility already. The accused contributions have to be understood through their powerful collective role as key members of the General Staff. They combined their individual statures into something that was even greater than the sum of its parts. And in those roles, they were able to disseminate the common criminal purpose, appoint JCE members and tools, coordinate their efforts, and deny crimes in an effort to blunt the international community's response. The common purpose submissions we've made already demonstrate the intent and knowledge of the accused. The crimes they are a part of are important JCE contributions. And the structures through which they operate evince each's effective control. What has been said to now goes to their individual responsibility too. I'm not going to rehash our briefs or the earlier speakers. What follows is best understood as remaining aspects of the evidence concerning the accused responsibility. I'm going to focus on select evidence concerning each accused and the arguments made in the defense final briefs. Because the same conduct establishing responsibility under JCE 1 or JCE 3 also alternatively establishes their responsibility under aiding and abetting and superior responsibility, my presentation will address evidence submissions concerning those alternative modes of liability as well. Let's start with Hashim Thaci. Unless otherwise indicated, all slides can be publicly broadcast. The Thaci defense argues in paragraphs 124 to 127 of its brief that the SPO has failed to prove beyond reasonable doubt that Thaci was a founding member of the KLA or a member of the GS or Central Staff prior to 1998. Mr. Teager touched upon aspects of this already, but the Thaci defense arguments do not withstand scrutiny. The Thaci defense is misleading in suggesting that Azam Sula, a named JCE member who would be in a position to know the initial membership of the General Staff, was inconsistent on Hashim Thaci's credentials as a KLA founder. In P847, Sula is talking about the composition of the first KLA General Staff. He's identifying Thaci, as well as Kadri Veseli and Recep Salimi, as founding members. In P1875, Sula is talking about something different, namely what he considers a founding meeting of the KLA in December 1993. He deliberately does not name all the attendees at that meeting, nor is he claiming to be fully listing the KLA's founders. Other evidence, like P186, shows that the KLA's founding was understood at an earlier moment, in April 1993, in a different meeting, not attended by Azam Sula, but was attended by Adam Yashari, Hashim Thaci, Kadri Veseli, Jakub Kresnici, and others. The evidence is only showing differences in classifying the founding moment of the KLA, not a discrepancy as to whether Thaci was one of its founders. As mentioned by Mr. Teager, when Thaci was asked by the SPO when he became a member of the General Staff, his response was that it was well known that he's one of the KLA's founders. The quote-unquote first-hand evidence the Thaci defense relies on at paragraph 127 to show that Hashim Thaci only joined the General Staff in November 1998 is from Sokol Bashoda, and him alone. And his testimony is contradicted by a wall of evidence, including Hashim Thaci's description of the inner workings of the KLA General Staff before then, in P771, and the additional evidence cited in paragraphs 101 and 482 of our brief. It's not even clear that the Thaci defense itself believes Bashoda on this point, as they argued in their opening statement that Thaci was invited to join this General Staff, quote, by spring 1998, unquote, before describing his logistics and media responsibilities. And that's at T2303 to 2304. Sokol Bashoda's evidence is incapable of belief on this particular point, underscoring the caution required when evaluating his credibility on matters which feed into his biases in favor of the accused. From Thaci's positions within the KLA, he contributed to the crimes charged in the myriad ways spelled out across paragraphs 482 to 507 of our brief. They are not mere contributions to the KLA's broader political goals or neutral contributions, as discussed across paragraphs 112 to 118 of the Thaci brief. The Thaci defense places particular reliance on the ICC's Mabrur Shamana case, quoting that case's confirmation decision at length as an example of how contributions to a broader political effort were found not to be contributions to crimes. That case does not aid in understanding the issues currently before this panel. The ICC doesn't use joint criminal enterprise. Joint commission there is defined as co-perpetration or indirect co-perpetration, and they have different elements to JCE. The Thaci defense says that Mabrur Shamana was charged with indirect co-perpetration under Article 25.3d of the ICC statute. That's not true. Article 25.3d is not the indirect co-perpetration provision at the ICC. What Mabrur Shamana was actually charged with is a form of residual accessorial liability which has no clear equivalent at this court. The ICC's more recent case law does not even look at the significance of contributions anymore in Article 25(3)(d liability, as can be seen in paragraphs 1242 to 1244 of the Al-Hassan trial judgment. A more apt citation in the present context would be to paragraph 1876 of the Case 202 appeals judgment before the ECCC, which does concern JCE and considers that even activities that are on their face unrelated to the commission of crimes may be taken into account when determining a significant contribution. More importantly, Hashim Thaci is a direct proponent of the common criminal purpose. You can see this particularly clearly in how he talks about the LDK, one of the groups targeted by the opponent policy. Here's a Lyria regional staff report discussed across T7799 to 7800. Thaci's intervention couldn't be clearer. He declares that those who do not recognize the general staff are criminals, and we will not leave the weapons in the hands of the criminals. We shall fight against them. Here's P486, where in a heated moment with Tahir Zemai, Thaci confronts him and says, "I will fight you, Tahir Zemai, like the Serbians, you and your units." And that is the same message you see shortly afterwards in Communique 53, where on 18 September 1998, the General Staff declared that only in Sverka, Prapachan, and Baran, where the deserters, former and UDB members, currently institutionalists such as Tahir Zemai had influence, the enemy did not encounter resistance, despite the fact that these villages were not spared from being burnt down and destroyed. These people will one day be held accountable for the damages they are causing to the people and the homeland. That is intentional staining of those who stand in the way of the KLA's control over Kosovo. Thaci's words to Zemai become General Staff words in a communique and then become reality when the Chires delegation is detained 2 days later, culminating with Thaci threatening W03825 that we could kill you in Pristina. Describing Thaci's contributions as neutral is farcical on the admitted evidence. It's not a neutral contribution to say these things from someone in Thaci's position. It's not a neutral contribution to interrogate and threaten detained, beaten people at Chires. You can also see a clear connection between Thaci's words, the General Staff's words, and the charged crimes with his first public appearance at P1256. Nuhi Batucci testified that he filmed Hashim Thaci saying this on 30 October 1998, as he discussed across T16722 to 16728.
Ushtria qlirimtare e Kosovës, si tërësi e forcave armatosura të Kosovës në nuheqjen e shtabit të përgjithshëm të saj, gjatë këtij viti u përball kundër shumë ofenziva të pushtuesit serb. Ajo arriti të bëjë ballë me sukses të gjitha këtyre ofenzivave, kështu që sot ushtria qlirimtare e Kosovës është më përgatitur si në planin kombëtar dhe në atë ndërkombëtar. Në planin kombëtar, Ushtria Çlirimtare e Kosovës, përkundër propagandës dhe luftës speciale që u bë para, gjatë dhe pas ofenzivave të kushtosit serb të ndihmuar edhe nga elementet autonomist, ajo arriti që vetëm të konsolidohet, të profesionalizohet dhe sot ka arritur shkallën më të lartë të organizimit të saj politiko-ushtarak.
Special war, autonomous elements, first appearance. The Thaci defense argues in paragraphs 244 to 247 of its brief that this speech shouldn't be relied upon for the proposition that Hashim Thaci publicly made such attacks because Bertucci removed the reference to special war and autonomous elements before it was broadcast in his documentary. But that argument misapprehends the true significance of this piece of evidence. First, that Thaci said these words at all is meaningful. They are a personal recitation of core tenets of the opponent policy, said in the expectation they would be publicly broadcast. Nuhi Bertucci admitted when testifying that he cut them deliberately, citing the need for the KLA to enjoy greater support from all strata. The witness knew the inflammatory nature of these words, which is all the more remarkable when you consider that Nuhi Bertucci encouraged Thaci to make his original speech more diplomatic, and he confirmed when testifying that this exhibit is the more diplomatic version. The original was even worse. As the witness described in page 381 of P1264 ET when seeing the draft before this one, quote, "When I read the first sentence, I did not like it because at the start of his public appearance, he was using extreme expressions. In a way, he was calling traitors all those who had not committed themselves to the KLA and those who did not support it," end quote. But second, and more fundamentally, Thaci's message against special warfare and autonomous elements is publicized by the General Staff in other guises. To focus on just one example, on 1 November 1998, the Military Police Directorate of the GS issues its press release number 4, discussed many times in the trial and seen here. It's the press release detailing the arrest of Cendescu and Jakub Kastrati, who are accused of cooperating with executed collaborators Ramiz Hoxha and Salman Benishi. And Mr. Tiger mentioned this earlier, but the Military Police Directorate justified Descu and Kastrati's arrest on grounds that they were in continuous coordination with Agim Krasniqi, a member of the LDK presidency who is known to the KLA intelligence service as an inspirer of the special war against the KLA and an initiator of a kind of autonomous police of Kosovo. Special war, autonomists. Again, this is 2 days after Thaci says the same things on tape, now in direct relation to crimes committed pursuant to the opponent policy. Thaci's messaging is a contribution to the crimes charged, and his first appearance is part of the evidence establishing this. These efforts must also be understood in tandem with Thaci's denial of crimes, such as the incident referred to by Ms. Lawson yesterday, of Thaci lying to Frederick Abrams' face about the 2 detained, mistreated Serbian journalists having received due process. Our brief has more on that incident at paragraphs 950 to 955. But the way that Hashim Thaci attempts to manipulate in that moment shows why caution is required in accepting international witness evidence about Thaci's role or command and control in the KLA PGOK more generally. The internationals didn't know he could demand 2 prisoners and take them from Dranots. They didn't know that he reinstalled Ramush Haradnai as Dukajin Zone commander over Tahir Zemai. They didn't know he could make military appointments like this one of WO4744.
On that day, on 6th of October 1998, he communicated my appointment to me. As I explained, the appointments of commanders at brigade level were carried out by the General Staff and by the Chief of Staff, Bislim Zurabi. So Hashim Thaci communicated the appointment to me and said that I had the right to form the brigade without the need for verification for the commanding staff.
The witness then clarified what that last point meant. One last question on this. Hashim Thaci also said you had the right to form the brigade without the need for verification for the commanding staff. I was just wondering if you could explain further what that means.
We were in a war situation, and for every formality, can this be done or that be done, made our work more difficult. So my conviction is that on this occasion, Hashim Thaci fully trusted me, and he wanted to put the most meriting persons on commanding position.
When Thaci is asked about this appointment by the SPO, he lies again, denying that it happened and going so far as to claim he doesn't even know who WO4744 is. And that's at pages 4 to 5 of P739.5 ET. What James Rubin, Wesley Clark, and some of the other internationals don't understand is that Thaci's willingness to shroud what was happening affected their ability to truly understand how the KLA works. Rubin and Clark in particular showed themselves to have no interest in truly understanding. Trusting their work was on the right side of history without grappling with what this panel is now asked to decide. Their conclusions were also not indexed to the international legal standard of effective control. The KLA's identified commander-in-chief may not have been able to exercise command like the armies of the United States or NATO. But he also doesn't need to. Paragraph 613 of our brief goes through a variety of hierarchies which have found to be sufficient for superior responsibility under customary international law, citing convictions for a provincial administrator, a civilian warden of a prison camp with no formal appointment, a media executive, and the director of a tea factory. The subsequent paragraphs of our brief go through the indicators of effective control, citing and cross-referencing to the evidence that shows a sufficiently working hierarchy to meet the legal standard for each accused. The Thaci defense relies at length on the impressions of its witnesses. They lacked basic information upon which to give them, and their conclusions go to ultimate issues. Those opinions should be given no weight accordingly. Finally, at paragraph 621 of their brief, the Thaci defense claims that Mr. Thaci did not have any obligation to refer crimes to internationals of which they were already aware. Even putting aside the concession in there that that means internationals can be competent authorities, the submission itself is groundless. Referring to the competent authorities is a necessary and reasonable measure when it is capable of contributing to investigating or punishing the crimes in the circumstances which prevailed at the time. And that is from paragraph 1933 of the Popovich et al. Appeals judgment. Such a referral would undoubtedly so contribute. U.S. KFOR officer Stephen Russell testified at T 18772 to 18773 that they did try to investigate crimes committed prior to KFOR's arrival when they received relevant information. The accused had an obligation to refer the crimes of their subordinates to any reasonably available competent authority. Competent authorities like KFOR, UNMIC, and the ICTY were all available, and referral would evidently been of value. That some information on some charged crimes may be broadly known cannot excuse the commander's personal responsibility to refer crimes to the competent authorities. Now, Kadri Vesely, who had the nickname Luli. Before getting to this accused, we note at the outset that caution is necessary when evaluating the arguments of the Vesely defense, and frankly all the defense teams, with what they say about untested evidence. Rule 140, 4A of the rules, governs this notion at this court. It provides that a conviction may not be based solely or to a decisive extent on the statement of a witness whom the defense had no opportunity to examine. Rule 139.3 is equally clear. A panel shall not impose corroboration requirements subject to those in Rule 140, sub 4. But the Vesely defense argues across paragraphs 37 to 42 of its brief that a conviction cannot be based solely or decisively on hearsay, which is a much broader category of evidence than statements of witnesses. A witness statement is a term of art in the statutory scheme that has been discussed too often in this trial. They have special disclosure obligations, special admissibility requirements, and special considerations during deliberations. When a witness comes and testifies about hearsay from others, this rule does not generally apply because those aren't witness statements and the reliability of the hearsay can be tested. The Vasselli defense argues against this with reliance on paragraph 69 of the Harakina and Marina appeals judgment. Just 7 paragraphs prior to the cited portion, the ICTY appeals chamber considered at paragraph 62 that, quote, not all evidence characterized as hearsay can be considered untested or unreliable. Indeed, as a matter of law, it is permissible to base a conviction on hearsay or circumstantial evidence, but caution is warranted in such circumstances, unquote. That is consistent with Rule 139.3 and the appeals panel's findings at paragraphs 329 and 330 of the Shala appeals judgment. Hearsay provided by a testifying witness does not, as such, fall under Rule 144A. Neither does evidence tendered through the bar table. Neither do admissions of an accused relied upon against that accused. And neither, for that matter, do adjudicated facts. Those can be relied upon in a sole and decisive manner, as held specifically in paragraph 452 of the Karadzic appeals judgment. Our case does not require reliance to a sole or decisive extent on any statement of a witness who the accused had no opportunity to examine. The defense teams are overextending this notion beyond previous cases and the rules of the KSC. As with all the accused, many aspects of Kadri Vasselli's individual responsibility have been discussed already. His intelligence responsibilities, what intelligence members do during the war under his authority, and his direct involvement in crimes. We've made reference to this quote of Mr. Vasselli's before as well. I want to focus on a different aspect of it. In fact, we have had our responsibilities during the entire wartime in the period 92 to 98. We had our general staff and the operational staff of the UCK. We did not have separate duties, but all did whatever we could. We were engaged in leadership, logistics, and intelligence because the circumstances were such. As noted yesterday by Mr. Teager, that's as clear an acknowledgement of collective decision-making as you'll find. But let's now focus on the timing in these remarks. Vasselli is talking about engaging in leadership, logistics, and intelligence from all the way back in 1992. Even before the 1993 KLA founding meetings discussed previously, Vasselli is engaged in leadership and intelligence. The Vasselli defense argues at paragraph 16 and 116 to 117 of their brief that Kadri Vasselli was never in the LPK, but that doesn't square with the evidence. In addition to those confirming Vasselli's LPK membership, like W04748 at T3512, Zavid Haliti at page 32 of P1857 ET, and Recep Salimi, page 3 of P761.7 ET, you can see here an LPK history document prepared by Emir Somali, who was the former general secretary of the LPK and was positioned to know how it worked. Zamali identifies Qadri Vaseli, Thaci, Fatmir Limai, Shukri Buya, and others as part of a list of persons recognized by mid-1998 as being LPK experienced activists in the diaspora. So what are the LPK's methods on intelligence that Vaseli was engaging in from 1992? In the words of WO4748 at T4177, quote, that the operational method of the People's Movement from Kosovo at the time, those who took over the KLA, their method was that before removing someone from the scene, they would slander them and accuse them of being a collaborator, and so on and so forth, unquote. The witness added that those who did not obey the People's Movement of Kosovo people suffered consequences, and that's what it was. In P2863 ET, Emir Somali explained that the LPK also made a 4-volume work on its strategy and tactics. The cover pages of those 4 volumes, known as Lirid on Kosovo, are in evidence. And Volume 1 covers what LPK intelligence was supposed to do. At the appropriate time, it should be made clear to the entire population that no one should think that the criminals will be spared or that they would remain undiscovered. Investigations are also conducted into those elements suspected of having collaborated with the reaction in order to discover the camouflaged traitors and spies. The clandestine squads can carry out various actions, such as the killing of spies and traitors. Lirid on Kosovo is just another example of the same methods you see in the communiques, the materials on intelligence duties, like P74 and P890, and from witnesses like WO4748, WO4747, and what Sokol Bashota tells the ICTY. The Vaseli defense focuses on a discrepancy in the 1993 Lirid on Kosovo publication date. But that does not change Emir Zamali's statements and evidence on the document's existence and the fact that its expose on intelligence duties aligns with other evidence. The argument in footnote 215 of the Vaseli brief that Emir Somali denied the authenticity of Lirid on Kosovo is improper and misleading because it is based exclusively on unadmitted evidence. The cited pages are to counsel's submissions, which are not evidence and cannot be relied upon. Let's now look at Qadri Vaseli's authority over JCE members and tools in the General Staff. Sabit Getzi and his connection to Vaseli has been addressed by previous speakers. Let's go back to an even earlier example where you can see Vaseli's role in appointments. P67 discusses how Zemgashi and Mahir Hassani were installed by the General Staff as the commander and deputy commander at Dranots in the spring of 1998. The Vaseli defense describes this report as wholly unreliable in paragraph 554 of its brief, despite them also saying it was, quote, clearly a report from the Dreadnoughts HQ, unquote, at T4054. In any event, this exhibit is corroborated by this authorization, placing Mahir Hassani at Dreadnoughts, which was found at Jakub Krasnici's residence. W04753 confirmed Zemgashi and Mahir Hassani were in charge at Dreadnought. And both W04748 and Bism Zarapi, who confirmed he's the person named Bis here, made it clear that it was the General Staff who put these two outsiders on top of the local Dreadnoughts unit, and not just anyone in the General Staff. Because you can see here at P607, a November 1999 interview from Bism Zarapi on these appointments. As I said, Mahir Hassani was with me, and he was listening attentively to my proposals, in which he was being given tasks to carry out later because I had started the posting or appointment of the officers to various zones in Kosovo. After this, I proposed to Hashim, Luli, and Sokol that Mahir Hassani should remain as an officer in this zone. Kadri Veseli and Hashim Thaci are personally involved in these commander appointments. Appointments for a Dreadnoughts unit whose activities were so notorious that the Veseli Defense's former lead counsel referred to it as a torture operation at T11602 to 11603. Veseli's not out of the country here. He's not disconnected from these events. He's part of the decision installing the men who oversee the torture operation, and one which, as Mr. Teeger pointed out in documents he showed earlier, shows signs of Vryn local staff intelligence cooperating with Dreadnought's military police. What happened after these appointments can be found in the Dreadnoughts and Malasheva sections of our final trial brief. But I now want to turn to two Dreadnoughts victims that were discussed earlier. But in order to be more specific now, we would request private session for about 5 to 10 minutes.
Without objection, please into private session.
Your Honor, we're in public session. Thank you.
Go ahead.
Thank you. You can also see Kadri Veseli's direct involvement in the charged crimes with detainee Milan Mitrovic. Paragraphs 515 and 998 of our brief discuss how Veseli personally transferred this mistreated person to Klečka. KVM report P4052 relays that KLA interlocutors confirmed to the KVM shortly after Mitrovic's capture that they were holding him and told the KVM they were awaiting direction from their higher command regarding his disposition. This report discusses how Mitrovic was detained in Klečka with the note of main HQ Luli next to it. Veseli gave a prior statement which put himself near the area of Klečka, around when Mitrovic would have been transferred. That's P787, paragraphs 4 to 7 and 13. A testifying witness gave evidence on being held in Klečka with Mitrovic, stating in pages 4 to 5 of P1134 that he and his cellmates had been badly beaten. The defense had an opportunity to examine that witness and Nazar Krasniqi about Milan Mitrovic, and this is all before getting to the evidence of W04839, W04747, W03875, and the broader pattern of detentions in Klečka. The Veseli defense is simply wrong when asserting in paragraph 600 of its brief that W04839 is the sole or decisive evidence against Veseli for this incident. And Kadri Veseli had still more information on crimes being committed, even beyond those for which he was personally involved. In July 1998, Mr. Tiger mentioned this yesterday, W02144 met with Kadri Veseli and Hashim Thaci. The witness warned about alleged KLA abductions and detentions from ICRC contacts in Malasheva, only for Thaci to deflect and say that the KLA was a regular army respecting the Geneva Conventions. I want to focus now, here's exactly what that witness said. I do not remember specifically what I said to Thaci, but I would not have raised specific allegations about particular crimes because I did not have evidence and I did not trust the propaganda from either side. However, I would have raised the issue in general terms of these widely reported allegations of detentions and abductions in the context of ICRC access. Veseli is in this conversation. The Veseli defense challenges the specificity of the information provided at paragraph 641 of its brief. But the witness is raising the issue of KLA detentions and abductions that were widely reported at the time and raising them with a view towards ICRC access for the detainees. As the ICTY Appeals Chamber ruled in the Hadziazanovich and Kubura appeals judgment at paragraph 28, the information putting the accused on notice need only be sufficiently alarming to justify further inquiry. It need not, quote, contain extensive or specific details about the unlawful acts committed or about to be committed, unquote. Kadri Veseli's failure to prevent and punish the crimes in his general staff intelligence roles is both a contribution to the charged JCE and a failure of his duties as a responsible superior. And his absences from Kosovo don't change that. Vesely could still exercise his authority in Kosovo whenever he wanted. In P1449, Paul Refstal writes about a dinner he is having in Brussels with Thaci, Jarpri, and Vesely, Luli, in January 1999. Refstal recalls telling them about an upcoming visit of Norway's Foreign Minister Knut Vollebæk to Kosovo. Here's what Refstal writes. The two of you know that Norway chairs the OSCE this year, I said in a didactic tone. Foreign Minister Vollebæk is in Albania today and is going to Kosovo in 3 days. I stopped for 2 or 3 seconds, as if to emphasize an important point was coming. Wouldn't it have been good for him to meet the KLA there? They looked at each other and exchanged a few words in Albanian. Then Jarpri got up, took out his mobile phone, and turned his back to call. He can go to Likots. We will ensure that he gets to meet someone from the leadership, he said, and sat down at the table again. We know this account is accurate because this meeting in Likots with Vollebæk occurs. Refstal mentions that the 8 VJ soldiers incident discussed yesterday becomes an international issue between that meal and Vollebæk's visit. When Vollebæk gets there, the meeting that he has with the KLA is recorded in the initial pages of P182, a notebook found at Recep Selimi's residence, and which we'll turn to again in a little bit later. The notes show a conversation with Vollebæk about the 8 VJ soldiers. Vesely and Thaci could communicate from abroad whenever they needed to. They were able to do it on a moment's notice from a restaurant. They maintain their control while abroad and their ability to prevent and punish, but fail to do so. Recep Selimi, you've already heard. Would you like to take a break now?
We'll take our half-hour break at this time. We'll reconvene at, wait a second, I think I'm wrong.
It's 10 o'clock now, Your Honor. We
We're
had
going
planned
to
for a break.
10:30, I'm sorry, my mistake.
No problem.
Go ahead.
You've already heard from yesterday about Recep Selimi's work all over Kosovo to monitor and enforce, amongst other things, the opponent policy. But let's start now with Recep Selimi's statements and media interviews. You rarely see a final brief more dismissive of what their own client said than that of the Selimi defense. Recep Selimi was presenting a romanticized version of the KLA at paragraph 57. They speak of the exaggeration inherent in his public comments at paragraph 327. His interview to Zeri in October 1999 is explained away at paragraph 59 as little more than uncorroborated hearsay. What the Selimi defense recognizes is that the things Recep Selimi says about the KLA illustrate his ability to contribute to the crimes charged. While we recognize that Recep Selimi's statements to the SPO and the media must be assessed with caution, there's no ground to summarily dismiss them. On the contrary, a cautious assessment shows significant corroboration for numerous relevant points. Let's start with a straightforward example. The September 1997 coordinated police stations attack, reflected in Communique 36. The Selimi defense describes this communique as, quote, a classic example of propaganda, unquote, at paragraph 304 of its brief. But why? Recep Salimi couldn't have been clearer that he planned this attack, as you can see here from his Zeri interview. We decided to coordinate our attacks, as was the case with the 14 attacks on 11 September 1997. I was in charge of coordinating these attacks. I was in charge of this operation on Kosovo level, jointly with other comrades, but I played a leading role in the coordination of these attacks. Suleiman Salimi confirmed his participation in this same attack at T24927 to 24928, and the Salimi defense asked no questions of that witness. The only thing exaggerated here is the claim of exaggeration. Recep Salimi was put in charge of the biggest coordinated strike the KLA had ever attempted to that point, and Communique 36 memorialized that attack. He's then the one speaking at the KLA's first public appearance, later in 1997. The indicators from the pre-indictment time frame confirm Salimi's importance. Salimi is acting through these positions during the indictment time frame to share the common criminal purpose and contribute to it. You can see this in his language, even before you can see it in him beating a detainee with a plastic pipe and participating in other charged crimes. We talked earlier about what Thaci said to the LDK and FARC in the Lyria Regional Staff Report. Salimi is also crystal clear about how he feels about this group, saying that the GS has never recognized and shall never recognize this institutional line, the parliament, the president. At T 17261 to 17262 and T 17289, an SPO witness recounts how Salimi told him, quote, "I will kill with my own hand all those who are with Rugova," unquote. When Ekrem Reja, Commander Drini, reports to internationals the charged victim Emir Jafici had been taken, a KLA commander asks Recep Salimi about this man. Salimi's reaction was to say, "He's not here, we're not connected with this case," and then, quote, "He will have to deal with me. I will personally kill Ekrem Reja Drini," unquote. And you can see this exchange at T8768 and page 18 of P492.3 ET. These are the threats if you get in the way of Recep Salimi, if you oppose or expose what is going on. That Salimi can exercise his effective control over people like Drini can be seen in his direct involvement in removing him as the Pastric Zone commander in early 1999. As we explain in paragraphs 405 and 407 of our brief, this decision was not made in a vacuum, but against a backdrop of increasing General Staff distrust of professional soldiers like Drini and those with perceived LDK or FARC affiliations. Islam Zarapi, W04769, W04737, and other witnesses implicate Recep Salimi in this decision. The Salimi defense arguments in response across paragraphs 446 and 451 of their brief focus on technicalities and motives that change nothing about Salimi's involvement. For example, The Salimi defense tries to explain away Bislam Zerapi's evidence on grounds that he did not know the exact procedure the Personnel Commission followed when replacing Drini. But we know that Recep Salimi is in that Personnel Commission by virtue of P1109. And Zerapi is clear in the very transcript portion cited that he, quote, was replaced because at the time there were consistent requests for Commander Drini to be removed from that position, unquote. With Zerapi then adding that it was Recep Salimi who was consistently asking for the removal. Salimi had the ability and information to address the behavior of his subordinates. And he took steps to remove someone like Commander Drini, but not someone like Suleiman Salimi, who was appointed by Recep Salimi and the General Staff only to perpetrate crimes with his men at Likots. Recep Salimi does nothing to stop his cousin Suleiman, and the evidence of Recep's presence amongst mistreated detainees at Likots gave him more than enough notice to intervene. But Drini is removed, and Suleiman becomes the general commander. The accountability mechanism is completely backwards. And that's by design. Look at the so-called Krodmir case in early May 1999. The case concerned 4 KLA military police under Hazi Shala who were involved in detentions and the mistreatment of persons. Hazi Shala was himself directly involved in earlier charged crimes, as can be seen in paragraphs 800 to 801 of our brief. Salimi shows up at Klechka, asks for the file, and then releases the military police officers. W04743, intelligence member that he was, then reports these developments to Kadri Veseli. The evidence for these events is collected at paragraph 252 of our brief. But Recep Salimi, being able to release KLA military police suspected of crimes, illustrates both his authority in the KLA and his failure to exercise it to release wrongly detained victims or to punish the perpetrators, and how that contributed to the JCE. That Recep Salimi is much more than a man fighting in the war can even be seen by the way his subordinates complain about him. Let's look at the notes of the meeting Salimi attended that the defense attempts to brand as a coup by the zone commanders. If you look through these notes at P182, you see the zone commanders complaining about Sokol Bashoda, not up to the job, and Jakub Krasniqi, respected but not the right person. How their deputy commanders are a matter of concern to them, and how the general staff has been ignoring their requests about this. We should have been consulted. They're complaining. And who's to blame for ignoring their requests and failing to consult them? Samuel Ustaku makes it clear. Recep Salimi, Hashim Thaci, and Kadri Veseli are responsible for this situation we are in at the moment. Across these same pages, Suleiman Salimi is so upset about requests being ignored and not being consulted that he tells the general staff that if something isn't done, he won't report, which only makes sense if he'd been reporting previously. These are the same notes where Suleiman Salimi adds that Hashim, Kadri, and the 10 have contributed to the war from the beginning. The 10 is one of those who has risked the most during the war. The 10, as we know, is Recep Salimi. The Salimi defense argues in paragraphs 441 and 445 of its brief that no evidence of the authorship of this notebook was produced, and it was not shown to any witnesses during trial. Of the many witnesses who were shown this notebook during trial are W04739, W04744, W04752, W04401, and W04290. With W02144, we also use this video of Recep Salimi writing his notes of the March 1999 Terstenik meeting in this same book. The relevant testimony is at T 16094 to 16097. The rings of the notebook in the video match what can be seen in P182, and the content of the notes match the content of the meeting. Recep Salimi's commitment to the joint criminal enterprise can finally be seen in his conduct as Minister of Public Order. Salimi is confronted directly with illegal police activities by General Mike Jackson. In P2525, Jackson stresses, in relation to KFOR's lawful authority, there can be no unlawful challenge to this lawful force. Mr. Salimi was asked to ensure that the PU's illegal activities ceased. The Salimi defense challenges, at paragraphs 471 and 472 of its brief, that exhibit is an inaccurate record because no such police force was created. And that's false, contradicted by, amongst other evidence, this Ministry of Public Order communique, setting out its police mandate in total contravention of UN Security Council Resolution 1244, MPO police officer identification cards, signed by Recep Salimi and seized from his residence, including this one, a former General Staff Special Unit Commander, Ayvaz Berisha. Other cards were also found at Salimi's residence, like this one, a former Dreadnought's Deputy Military Police Commander, Selim Krasniqi. The holders of these cards had permission to carry firearms and to identify persons and bring them to the police. Salimi, in his ICTY testimony and SPO interview, cited in footnote 2210 of our brief, confirmed that he and the MPO issued these cards and then, in August 1999, withdrew them as demanded by KFOR. But the MPO continued to issue them, as you can see here, from a September 1999 ID card from Malaim Latifi, a former military policeman connected to the detention and mistreatment of opponents. And of course, there's P1539, a report seized once again from Recep Salimi's residence from Karadak Military Police Commander Fatmir Mehmeti, complaining about KFOR's raid of the charged Gilan detention site, which Stephen Russell testified as including the discovery of a torture room. Recep Salimi cannot escape the materials in his possession and the words he's spoken in the past, all of which show him to be a full and willing participant in the joint criminal enterprise. And finally, Jakub Krasniqi. Before we get to Krasniqi himself, we preliminarily wanted to address the submissions on aiding and abetting in Section 6 of the Krasniqi defense brief. What is argued there is materially in error. The Krasniqi defense argues at paragraph 771 that the prosecution cannot invoke the same alleged acts and omissions it relied on as significant contribution to an alleged JCE and treat them as proof of aiding and abetting. The authority for this proposition is paragraph 91 of the ICTY's Kavochka et al. Appeals judgment, and the attempted reliance on that case shows that there's a need to distinguish alternative charging from alternative convictions. All the modes of liability charged in this case, JCE 1, JCE 3, aiding and abetting, and superior responsibility, they're all charged in the alternative. We have asked for findings to be made on all of them, but only one can be the basis for a conviction on the same set of facts. The error in Kavochka was essentially convicting for aiding and abetting a joint criminal enterprise, which was reversed on appeal on grounds that chambers cannot stack alternative modes of liability in this manner. But that's at the conviction stage. In paragraphs 101 to 102 of the Nalatilich and Martinovich appeals judgment, the ICTY appeals chamber considered a defense argument that alternative charging based on the same conduct was prejudicial. The court there held that alternative charging on the basis of the same conduct was generally permissible before finding it to be permissible in the circumstances of that case. We absolutely are allowed to invoke the same acts in both JCE and aiding and abetting context. That is basic alternative charging. Your Honor, I'm at the point where I'm now going to go into a new section. We could take the break here and still comfortably finish by 12, but I'm in Your Honor's hands if you'd like me to continue to the break.
We'll break now, so you don't have to interrupt your discussion. We'll come back at 10 minutes until the hour, 10 till 11.
All rise. All rise.
Be seated. All right, Mr. Halling, you may go ahead.
Thank you, Your Honor. When it comes to the evidence against Jakub Krasniqi, the record is replete with his inflammatory statements, decisions he takes in his general staff roles, and the abundant materials found at his house, which confirm that what he was writing in his books and saying to the ICTY was what he was really doing. And what he was really doing was far more than being just a spokesperson, going both to his JCE contributions and his effective control. As mentioned earlier by Mr. Poch, Jakub Krasniqi admits in his book to writing those provisional regulations of the Army, complete with the military police being tasked to be merciless to all those who oppose and sabotage the Liberation War. As set out in paragraph 126 of our brief, different versions of these and other regulations were found at Krasniqi's house, just as you would expect from the drafter. Krasniqi is involved with formal appointments, including his admission in P189 ET.1 that Ahmet Isufi was appointed as the Karadak zone commander on his proposal. And the page for that is U015-8876. That's the same Ahmet Isufi who could only react in silence as US K4 was showing him that torture room in Jalan. Krasniqi oversaw the KLA legal sector, conveying Sokol de Brune's appointment, informing him about KLA prisons in Klečka, Kravisari, and Ladroch, and later advising de Brune about how to speak with internationals about 5 captured elderly Serb civilians. The evidence on these points can be found at paragraphs 250, 553, and 567 of our brief. But, despite his authority over de Brune, Krasniqi does nothing to ensure that the military court can proceed against any of the crimes charged. The Krasniqi defense attempts to explain away the decisions and orders Krasniqi makes by claiming them to be merely formalizations of earlier decisions or collective decisions that he was just conveying. But such arguments don't change that he is part of the group making the collective decisions. He's not just a messenger. In paragraph 727 of their brief in particular, the Krasniqi defense dismisses some of Krasniqi's signatures as, quote, bureaucratic processing, not command authority, unquote. This is the same defense team which at paragraph 120 relied on James Rubin's evidence that the general staff was just a hut with a bunch of couches. So the general staff is too primitive to do anything, except it also has a bureaucracy so entrenched that Jakub Krasniqi's signatures are needed to keep it moving. The Krasniqi defense also argues at length that the SPO has cherry-picked Krasniqi's statements, not providing necessary context to understanding them. Some of this is just refusing to see reality. There is no contextual argument that can save Jakub Krasniqi when he says that those we have kidnapped are either announced in a list or reported to be executed. There is no ambiguity in publicly warning collaborators that they would be killed if they continue to follow the wrong path. At paragraph 419 of its brief, the Krasniqi defense resists any attempt to contextualize this statement as an admission of past killings. But the question that Krasniqi is actually answering about killing collaborators who continue on the wrong path is this. The KLA is frequently assessed as a terrorist movement. Why does it kill peaceful Albanians? The Krasniqi defense's interpretation of their client's remarks in the wake of the detention of the Savalic brothers in early 1999, discussed across paragraphs 384 to 388 of their brief, is an even more glaring example of not putting words into proper context. If you look at the entirety of Jakub Krasniqi's conversations about these detained brothers, Krasniqi's claim that they shouldn't have been abducted is made in the course of a longer dialogue about how to explain themselves to the international community. Without broadcasting this slide, we can quote part of what was said in public session. Krasniqi's talking with Sokol Bashota. Bashota asks, "What should we do? What should I tell them? That they were civilians or what?" Jay, believe me, I don't know what you should tell them. Bashota then comments on Drini informing the internationals about the woodcutters, saying that Drini screwed us when he released one of them. It's only in response to that that Krasniqi says they shouldn't have abducted them in the first place, but we'll see what we can do. This isn't a lament on criminal acts. This is a discussion about damage control after they got caught. Context is also required at looking how Krasniqi defends the killing of Ramiz Hoxha and Salman Benishin to the ICTY. This and all remaining slides can be broadcast as public. Here's what he says in relation to their execution. I think the word execution here has been used in another sense of the word. They must have been killed, according to the information I had, but they were giving information to the force, to the Serbian forces in Maleševo. These two men are linked to the detention of Cendescu and Jakub Castrati, as mentioned earlier in relation to P303. And what's on the screen now has to be read with what Krasniqi tells the ICTY about collaborators in P794, where he adds that, quote, "Such people, collaborators who were numerous, they have received little punishment for what they were. They were in the service in the violent Serb regime. Such people did not deserve a better fate for serving the most criminal regime that has been known by the peoples of Europe after Second World War," unquote. There is no evidence on the record that Hoxha and Benishin were actually engaged in such activities. W03165 and W04278 couldn't have been clearer. They were not. They are killed all the same, with that execution warrant found next to their bodies, mentioned earlier by Mr. Tiger. The Krasniqi defense argues at paragraph 53 of its brief that Jakub Krasniqi's ICTY evidence must be given reduced weight because it was compelled. They neglect to mention that they made that same argument already when his ICTY statements were first tendered. In decision FO 1917, Your Honors rejected those arguments. There was then an interlocutory appeal, which found harmless errors before finding that no violation of self-incrimination was established and upholding the decision to admit the statements. The Krasniqi defense, trying to argue that admissions of their client cannot be relied upon for fair trial rights reasons, cannot be countenanced. Krasniqi's assertions about his hierarchy, his authority before the ICTY and in P189, they align with the evidence. Krasniqi had a handwritten annotation on a draft KLA statement at his house, said at P1447 ET that we should respect the hierarchy with fanaticism. P3765 are meeting notes found at Salimi's residence, which record Krasniqi as saying that nothing should be signed without the GS consent. These aren't idle statements. Look at how he takes control of the 8 VJ soldier negotiations. Look at his involvement in Blaram Kuchi's arrest. The Krasniqi defense attempts to resist the level of authority that their client had cannot withstand the totality of the evidence. The Krasniqi defense argues at paragraph 719 of its brief, for instance, that, quote, Mr. Krasniqi's presence at Flag Day on 28 November 1998 does not suggest authority, unquote. Let's pull up that video now.
Dashur ushtar dhe e pror. Gëzuar fesën e flamurit.
Now let's play Jakub Krasniqi's transparent reference to special warfare at that same event.
Shtria qimtare Kosovës stojnë në shumë fronte, se cili më egër se tjetri, se cili më finok se tjetri. Luftoj kundër një makinerie të tërë ushtarake propagandistike, përballoj ofensiva ushtarake të papara pas luftës së dytë botërore në Kosovë, përballoj një luftë speciale të koordinuar nga jashtë brenda dhe eci pa ndalshëm përpara. Dhe çuditën miqt dhe armiqt me dijetesen e ushtrisë shqiptare të Kosovës. Me gatishmërinë dhe vendosmërinë e saj luftërore. Qëllimi i armiqve të gjitha ngjyrave ishte zhdukja e QK-s, eliminimi i saj nga jeta politike, që pastaj Kosovës i imponohet një zgjedhje parancishme mjerake, pacifiste apo gandiste.
The KLA hierarchy is hardly perfect, but the indicators of effective control are there for all to see. Your Honors, the JCE charged in this case involved a combination of public dissemination, execution, in particular by intelligence and military police personnel, and policy monitoring and enforcement. each of the accused assume portfolios in one or more of these areas in the GS and PGOK to advance their shared objectives. The decisions furthering the criminal purpose, which fall under those portfolios, are attributable to each of them. Some decisions they sign, some they admit to taking, but all are ratified by each accused through their continued participation in what is being done in their name. Communiques calling for the killing of collaborators, regulations that codified merciless treatment, appointments of those advancing the criminal objectives to higher echelons of responsibility, decisions to take and execute Serb civilians. The list goes on. It is in full conformity with individual criminal liability to hold individuals responsible for their part in collective structures which are abused to commit crimes. The accused created a collective decision-making structure, then spoke the words, made the appointments, participated in the crimes, and enabled the continued pursuit of criminal means by which to seize control over Kosovo. This isn't guilt by association. This is guilt by purposive affiliation. Their acts and conduct establish that each made a significant contribution to the joint criminal enterprise charged. Thank you, Your Honors. I will now turn to Specialist Prosecutor West for some concluding remarks.
Madam Prosecutor, you may proceed when ready.
Good morning, Your Honors, Madam Registrar, everyone in and around the courtroom. With over 5,000 exhibits admitted and over 28,000 pages of transcripts, the record of evidence in this case is voluminous. It includes the live testimony of 130 plus witnesses taking place over the course of 227 trial days. Moreover, the court will consider the written statements of an additional 130 plus witnesses. It has been the privilege of my office to meet so many people who've lived through and witnessed the events described in this evidence. People, including the accused, who fought for their country against great odds. People who contributed in other ways, providing local leadership or distributing aid. People who strove to support and protect families in times of war. And people who have had to live for more than 20 years with the consequences of crimes senselessly inflicted upon them, including the victims of crimes charged in this case. It has been the work of my office to bring justice to them and bring accountability to the individuals responsible. These efforts in this prosecution concern the most sacrosanct principle of justice, the rule of law. Indeed, upholding the rule of law during the most dire of times, wartime. Many years have now passed, and justice has seemed unlikely to those who have lost their loved ones but the rule of law comes in to ensure that no one is above the law. This means that even those who are most powerful are held to account. We request, based on the evidence presented, which establishes their responsibility beyond a reasonable doubt, that the accused be held to account and sentenced accordingly. Your Honors, thank you for the opportunity to address you today. This concludes the SPO's closing statement.
Mr. Laws, we could wait until after lunch if you wish, or we could start now. I'll leave that to you.
Well, I'm very happy to start now if I'm given the choice.
You're given the choice.
That's the choice I'll make then. Thank you.
Okay.
In Kosovo, in Serbia, and in the diaspora around the world, there are people waking up today with pain in their bodies, with sorrow and loss on their minds, and without people that they loved. They are victims of crimes committed by members of the KLA in 1998 and 1999. There are 155 of them admitted to participate as victims in this case: Albanians, Serbs, and Roma. And it is on them that I want to focus in the course of these submissions that I make on their behalf. It is no exaggeration to say that these crimes have left deep and ugly scars right across the world. One could well say that it was inevitable that the KLA's struggle for independence would lead to people losing their lives. That is a consequence of conflict, and nothing that I say involves any judgment at all on the rights or wrongs of that struggle, nor any judgment on the KLA as a whole. Many victims supported the KLA. A number were members of the KLA. This is not about denigrating that institution. It is about the conduct of some of its members and the repercussions on the lives of those that I represent. So it was inevitable that life would be lost. But was it inevitable that this struggle would lead to the cruelties and to the deaths that this panel has heard so much about? Was it inevitable that a liberation war would involve so many people losing their liberty, or civilians from all communities being tortured and some losing their lives while in the custody of the KLA? You will have to decide why it was that these things happened. Did these events have their origin in the minds of men intent on power, or did they occur spontaneously and in a manner simply beyond the control of the KLA's leadership. Of course, it's a decision of great importance to the victims. Many of them are baffled to this day about what happened to them. I have some slides which, with the help of the court officer, we're going to be looking at. And if we could have the second one, please. All of the slides in this presentation can be broadcast to the public. 3 victims separately asked effectively the same question in this courtroom in the course of their testimony. Why did dreams and flashbacks beset by a general sense that the world is not as it should be? Why don't my arms or my legs or my hands or my eyes or my ears work as they should? Why can't I speak openly about what happened to me? Why did I have to move to a foreign country and leave everything I owned and cared for behind? Well, why did it happen to them? It's a question that has an obvious relevance for every victim in this case, and it also goes to the very heart of the case. Why, in 1998 and 99, in Kosovo, were people being taken away from their homes at gunpoint, or stopped at a checkpoint, or at an office, or going about their daily business and being put in cars by armed men? Why were they being taken? And once taken, why were they beaten, tortured? Why were they held in filthy and degrading conditions? Why would so many of them not see their homes or those that they loved again? Why would they end up in graves that were unmarked and unrecorded, adding an extra torment to the lives of those left behind? The answer can come in a number of forms. The immediate cause of it happening was the willingness of some soldiers within the KLA to behave with great cruelty and with a disregard for the lives and well-being of others. And we suggest that that can only be because at some level they saw the allegation that a detainee was a collaborator, or the fact that a detainee was a Serb or a Roma, as sufficient to justify and excuse their conduct. Seeing oneself as beating up an enemy of the people in a patriotic fervour is, one imagines, more palatable to the conscience than seeing yourself as tormenting a farmer or a teacher or a firewood seller or a student for no reason other than the enjoyment of violence. What those who commit these crimes either don't understand or just don't care about is their lasting impact on their victims and the way that the effects of such crimes spread and affect the lives of their innocent loved ones too. This context is provided by the victims, and it is a necessary one. Why do we do these cases at all, if not out of regard to the suffering of the victims? These cases and this case, they're not case studies. This indictment is not just a dry legal description of criminal acts. It's about times and places where people have come to serious harm, harm that has changed them and their families forever. By acknowledging that harm, a court is able to say that it has listened, that the suffering of the victims has not gone unnoticed, even amidst the whirl of a very large case like this. In the end, what we hope for is that the victims have been given a voice here and that it will have been heard. And that is perhaps a good point at which to move on to look at their experiences and at some of the evidence. And if I could have the next slide, please, Mr. Court Officer, thank you. I'm going to deal with the different types of harm under 4 headings and then finally make some concluding remarks. We're going to look at detention and mistreatment. We're going to look at the indirect victims of detention crimes, at the loss of loved ones, at exile and the loss of home, and then some words at the end about the importance of this trial and something about the future. So I'm going to turn to the first of those topics, which is detention and mistreatment. For an Albanian, much the most common route into a KLA detention camp was to find oneself labelled a collaborator, or for some other reason to be seen as an opponent. For a Serb or a Roma, it seems to be the case that one's ethnicity alone could be a sufficient basis to be taken. For some, it was a one-way journey, a journey from which they would never return. But for others, it was an experience of disappearing, some just for hours, some for months, into an unfamiliar world in which violence and cruelty were constant companions. I want to emphasize, first of all, certain aspects of the experience of the Albanian victims who were labelled as collaborators, because their harm and the harm suffered by their families is quite specific, and it is enduring, and it needs to be seen in its full context. I'm going to deal with the headline topic of detention and mistreatment under 4 subheadings, and this is the first of them. The basis of the accusation of collaboration. Viewed from the perspective of its victims, the policy of detaining collaborators had, from its very inception, one serious flaw. How do you know who's a collaborator? How do you determine that issue in the absence of any meaningful legal process? In truth, no serious effort went into the task of identifying whether a person was a collaborator. People were snatched on a basis that was often no more than rumour. It's very hard to believe, isn't it, that someone could lose first their liberty and then their life on such a flimsy basis. But they did. This network of KLA camps was being operated with a presumption of guilt. People were detained for reasons that were utterly opaque and in a manner which was guaranteed to produce injustice. More than one Albanian victim spoke about how they had to deal with Serbs in their community in order simply to get by, whether it was in business or whatever, and how that became twisted into an allegation that they were collaborators. It was as if the apparatus that was making these decisions was actively looking for ways to accuse and detain people. As the saying goes, give some people a hammer and they'll think everything's a nail. Suspicion fell far and wide. And so a whirlwind of detentions swept across this corner of the world, with terrible and fatal consequences for many. My second heading under this topic of detention and mistreatment is the failure to investigate allegations against detainees. It's a feature that seems very remarkable in this context, and it's the way in which, once people had been brought into detention, there was hardly ever any real effort put in to trying to establish if a person was a collaborator or not, or was guilty of other crimes or not. Guilt had been presumed. The focus was on beating and mistreating people and insisting that they confess to crimes. They were very rarely presented with the basis for the accusation and given a meaningful chance to respond to it. Where there was some gesture towards finding out the truth, it was just ignored if the answer wasn't the one that was wanted. Take, for example, witness 2018, who was accused of a specific crime. When the supposed victim of the crime exonerated him, it made no difference. He was simply beaten again. My third subheading under this topic is this. It's the exceptional cruelty shown by some KLA soldiers in charge of prisoners of all ethnicities. The cruelty that has been evidenced in this case was extreme. It wasn't enough to punish people by imprisoning them. In nearly all cases, the detainees, the victims that I represent, faced disgraceful and horrifying treatment. An almost complete absence of due process is really just the start of it. And the prosecution touched on this topic yesterday, but I want to return to it with some examples that are all drawn from the experiences of the victims in this case. We have heard of people being shackled in a barn, surrounded by animal waste, of rooms that were freezing in winter and boiling in summer, of detainees being deprived of food and water, and of any information about how long their ordeal would last, or whether they would survive it. We have heard of victims being electrocuted, struck with hot irons, urinated upon, having salt thrown in their eyes and on their wounds, being beaten on their genitals with such ferocity that they became infertile, being the subject of mock executions as well as real ones. And we have heard about beatings, about an endless number of beatings. The detainees were beaten by soldiers who were young, but even then should have known better, all the way up to senior figures like Sabit Getsi, Jemjit Krasniqi, and even, if the SPO are right, Recep Salimi. They were beaten by women, by other prisoners compelled to beat them, by passers-by, press-ganged into beating them. They were beaten with rods and with sticks, and with batons and pipes, with rifle butts and baseball bats, and with pretty much anything else that came to hand. Many were beaten until they were unconscious. Some were beaten several times in a day, and some for day after day. Why were they treated with such cruelty? Witness 778 was treated for injuries to his hand at a KFOR base. Pliers had been used on it in Vauban. The doctor who examined his injuries expressed his disbelief that something of this kind would be done in the 20th century. That's P 2511.5 at 9. It's not uncommon to hear victims say that they thought they might die. They knew that others were dying in detention. Some actively wished for it to happen so that their suffering would come to an end. And who can blame them? I'm not sure that any advocacy can do justice to the ordeal of captivity as it was experienced by the victims in this case. As the panel will recall, we called some expert evidence on this topic, and if I could have the next slide, please. Slide 4. We called experts from 2 mental health experts with careers that are focused on torture and dealing with issues of captivity and of the victims of crimes of this kind. And what they said is that captivity is one of the most challenging human experiences. Captivity is something which we have heard many, many victims endured. And the next slide, please. They endured it in circumstances which this slide has a particular relevance to. The treatment of prisoners by prison staff during captivity is the most important predictor of the development and persistence of post-traumatic stress disorder. And they added to that it's the complete loss of control and the complete dependence on one's captors that makes captivity uniquely traumatizing. And that's at T 26224 and 223. The personal nature of that violence from one's captors is a key feature distinguishing captivity from other life events. And if we could have the next slide, please. The experts went on, we know that trauma caused by one person to another has a more profound effect than, for example, a traumatic experience caused by a natural disaster. By our count, it's 50 victims in the case who were detained in KLA detention sites. Their accounts of their ordeals and of the violence and mistreatment meted out to them must be read in the light of this expert evidence. Captivity, a uniquely difficult experience, the personal violence of the prison staff towards the detainees, bringing into play that additional factor of the person-to-person element that is so debilitating in the long run. Their first-hand experiences are too numerous for me to deal with here. They're set out, as your honours know, in great detail in our impact statement. And I'm going to just touch on a few. W2652 learnt what it is to be mistreated as part of a group. When one of you is beaten, it's like you're all being beaten. That's T 3027. So it's that very, very personal violence again. W3879, he learnt about what it is to be tied up whilst captive, so that anything can be done to you by your captors. An extreme experience of the helplessness that the mental health experts refer to, the loss of control. And that's at T6395. Or W4419's description of being electrocuted, lying face down on the floor, and how his body shook as the current passed through it. Or 4305, describing how, when he saw his body after his release, the sight of it, bruised and swollen, made him scared. These are not experiences that anyone should have, and it should come as no surprise that they can leave a permanent mark on the mind as well as the body. And that brings me to the fourth and last topic within the heading of detention and mistreatment, which is the consequences for the victims. Some people have never been free from the effects of these crimes, from the time that they were committed until now. And the mental health experts told us that the idea that time heals all wounds is unfortunately not supported by research. And it is not proved accurate for many, many of the victims in this case. Of course, there were the immediate consequences, the bruising and the pain, and for some it took time for that to heal and for the shock to subside. Sometimes this required a period of turning away from the world. W1679 spent months at home recovering from his injuries and living, in his phrase, like a shadow of a man. And that's V35 at V18. But many of the victims required medical treatment over the years, and many live with the physical consequences to this day. For others, the physical recovery was really the least of their worries. It's the psychological harm that has really changed their lives. It's the flashbacks and the anxiety. It's the inability to sleep. It's being easily startled. It's the fear that you're being followed or watched. It's the sense that the world is no longer a place in which you fit easily. And for some, sadly, it has meant inpatient care in psychiatric facilities. For others, it has meant thoughts of suicide. It has led to extensive counselling and to long-term medication. But it's the individual stories that show the consequences most clearly. Take 344 as an example. He told us that his personality had been killed. He can't bear to be alone, but nor can he stand to be with other people. He's too aware that they are well and he is not. He is irritable, sleeps badly, still receives psychiatric care, still takes medication. For 305 is also not free, despite having been released from detention 25 years ago. If I could have the next slide, please, slide 7. for no reason, I have these sudden episodes when I relive what I went through. It just comes back to my mind. And at that moment I lose my sound reason and I become upset or irritated. And so I step aside from people if I'm in a social gathering or if I'm at work. So I need to step aside and recover my senses and calm down. And he's by no means alone. We deal with individuals in the impact statement who suffer flashbacks, and the evidence makes clear what an impact this condition can have on a person's life. But that description of it is an individual and obviously heartfelt one, and it illustrates how suddenly and for no reason what was done to him is now in charge of a person's mind and thoughts, and he loses, as he says, his sound reason. The mental health experts helped us a bit with what that's like, and if we could have the next slide, please, on the topic of flashbacks. Thank you. It is not thinking about or remembering the experience. It's actually experiencing it as if it was happening again, with all the sensory elements of that. So people will smell the smells they smelt. They'll also feel pain. Sometimes they felt in parts of the body that were in pain at the time of the actual event. So that makes it hugely emotionally distressing. And if someone has experienced a flashback and is, say, coming back out of it, you see the level of emotional distress can be very high. Time needed to recover from it, to realize that someone is in the here and now and not in the memory that they were reliving. And perhaps just one other example of time not healing wounds. Witness 4781 can fairly be described as a big, strong man. He told you that he was scared of the dark, and he slept facing the door in case the men should come again, the men who came before and took away people that he loved. These are serious and very debilitating conditions. And it does mean for some victims that they are never free from what happened to them. And in summary, we say that the KLA detention centres were a prolific breeding ground for mental illnesses, just as they were for physical ailments and conditions. It's the end of my first topic, and I'm going to deal next with the topic of indirect victims of detention crimes, and this one will just take a few moments. The harm inflicted on individuals as a result of their detention inevitably spread to their relations. Witness 4870 was present when her family member was taken. She suffers to this day from a range of life-changing symptoms, including flashbacks, of which she gave a vivid description when she came to testify here. She had a flashback coming into this courtroom, the black gowns triggering a memory of the men who'd come in the night wearing black and carrying guns. Two other examples, both of victims who provide agonizing accounts of what it was like to visit a relative held in one of the KLA's camps. Witness 4371 remembers seeing his father in detention. He looked sad and shocked, and his son could see in his eyes that he was asking for help, but there was nothing that the family could do. And to this day, 4371 is haunted by that image of his father's face as he goes to sleep. And that's T15277. Witness 4811 also saw her father in detention. He was tired, hungry, weak, crying, unclear what he was supposed to have done wrong. Both their fathers were going to be murdered. Their children's lives contain these last memories of them, and will do so until they too are dead. For the prisoners who survived, their families had to live with different consequences. In the case of witness 4733, for example, that meant for his family welcoming home a broken man, a man who would never work again, nor know peace of mind after the horrors of his detention. A different father, a different husband, damaged, needing care instead of giving it. My next topic is the loss of loved ones. This category of harm is perhaps the easiest for all of us to feel empathy for. We can all imagine, and perhaps some have experienced, what it is to lose someone we love. But it has its complexities too. First of all, first and foremost in this case, the absolute injustice of it. We've already looked at the arbitrary nature of the detentions, and the murders were no less arbitrary, but obviously even less excusable. There are 84 victims who are relatives of murder victims participating in this case. Within that group, 20 victims have family members who were subjected to acts of enforced disappearance as charged by the prosecution. Another 66 have loved ones who were imprisoned and never seen again, or were eventually killed, but in relation to whom that there isn't a charge of enforced disappearance. What connects all these victims, regardless of whether they are Serbs or Kosovo Albanians, or whether they are victims of enforced disappearance or simply of murder or imprisonment, what connects them all is that they suffer a particular form of harm, not knowing exactly what happened to their loved ones, why it happened, and who was responsible for it. A joint statement last year by the Council of Europe and other human rights bodies emphasised the nature of this harm. And if we could have slide 9, please, the next slide. Enforced disappearances entail a serious violation of multiple human rights, inflicting profound suffering, experienced not only by those who are forcibly disappeared, but also by their families, their communities, and by society as a whole. They're often practiced as a deliberate strategy of control through terror, intended to cause suffering, instill fear, suppress dissent, and punish entire communities. And we'll return to one community in particular, one Serb community in particular, in just a few moments. Many of these victims are still searching for answers. We could have slide 10, please. Witness 72 is reconciled to searching until she dies. She said this, and to be strong still 25 years later, and to keep searching for my son and my husband and everyone else who perished in this way is really very hard. It's not easy, and I would not wish any other parent to live through what I've been through. When they took my son away from me, snatched him from my arms, so to speak, it's as if you lost one half of your heart. And the other half I still have left for the other part of my family. And this is how I live on, and I shall die with this. And I'll take these thoughts with me when I expire my last breath. I'll be thinking about my son and my husband. As the court knows, many of the families involved spent years hoping to find some remains. Some were fortunate enough to do so. Some never found anything, others just a part of a body. Being unable to bury their loved ones for years on end or permanently is a particular way of being harmed. It means not having a grave to visit, or knowing that the grave that you do have contains an incomplete set of remains. A number of victims encountered nothing but obstruction when seeking to find out what had happened to their family members. And in this context, I want to make special mention of the families affected by the murders following the KLA's attack in the Rahavets area in 1998. And we've heard a little about the facts of this from the prosecution, and the facts are well known. The communities were attacked, a lot of people were taken prisoner, men, women and children. They were held against their will. They were terrified out of their minds. The men and women were separated. A 16-year-old boy was put together with the men. They were mainly people who worked the land, also a teacher. They were driven away. And at some uncertain point afterwards, they were shot. And then their remains were concealed in a cave, with efforts being made to disguise their identities, possibly by the use of fire or explosives. This was a crime against an entire community, which was destroyed by the actions of the KLA, as if it were of no more value than an inconvenient weed to be torn up at the root and cast aside. This was a tight-knit community with strong ties between the various families. As a result, many of the victims lost multiple family members, as well as a wider kinship group. And for years afterwards, they lived with uncertainty. As rumours circulated about what had happened to their menfolk, they were never able to get the slightest clarity until the grim discovery of some of the remains in 2004 and 2005. They all also lost their homes, the physical buildings and the place that they called home. None of this group has ever felt able to return. They are, however, still a community and still support one another through their awful shared experience of murder and of loss. And there simply has never been a proper reckoning in relation to these terrible crimes. The families regard their involvement in this case as a way of continuing to do right by the ones they have lost. It is the last and perhaps most touching of ways to show their enduring love. To have that loss acknowledged is a way to provide some measure of consolation. I will be returning to that this afternoon. It's very important that I emphasize to you the significance of acknowledgement of that kind for the victims. Your Honour, if that's a convenient moment.
Thank you. We'll be adjourned until 1:30. We're adjourned.
All rise. All rise.
Be seated. Mr. Laws, just for scheduling, what's your time frame on this, the rest of your presentation?
Somewhere between 20 minutes and half an hour.
I take it you want to start tomorrow morning, is that correct?
Yes, please, Your
All
Honor.
right, I think we sort of anticipated that. All right, then you may proceed.
Thank you, Your Honor. We had been looking at the topic of the loss of loved ones and dealing specifically with the Serb families from Rahavats. These families, but also many other families who lost a loved one to a murder, were exposed to what the mental health experts called ambiguous loss. Ambiguous loss is when all the circumstances suggest that your family member is dead, but there's no confirmation. For example, no body has been recovered. And as the experts explained, the uncertainty implicit in ambiguous loss is traumatic in its own right. The lack of clarity gives family members hope, and that makes it difficult to find closure. And we see this observation from the experts also reflected in the experiences of the victims. Witness 4489, who lost her husband but never had proof of his death, spoke of how 25 years of living in uncertainty amounted to torture. That was her word, and that's at T11377. We have heard and read about, in the evidence, family members of the missing going from pillar to post, knocking on whatever doors they could find, even placing adverts in the press, pushing on against all odds, because, as 4566 said, it's hope that dies last. That was at T6959. And if we turn to look at killings by the KLA more generally, not just those that have involved this ambiguous loss, what we find is that they were ignored, they were covered up, and they were concealed, when of course they should have been investigated, documented, and prosecuted. Even to talk of them was taboo in Kosovan society, and some victims learnt to be silent. Witness 4712 said that the family didn't talk about the death of their loved one. They were silent through fear. Fear that the same thing could happen to them. But keeping silent made the grief even harder to bear. And that's V17 at 2549. The hidden nature of these crimes contributed to further stigmatization of the survivors within their communities. The fear and sense of stigma is particularly strong even today among the Kosovo Albanian victims who still live in Kosovo, but also among other victims who've left the country out of fear for their safety. And it goes without saying that many of these families lost not just a loved one, but a breadwinner, and found themselves on top of everything else, having to find a way to make ends meet. The next topic that I'm going to deal with within the heading loss of loved ones is transgenerational harm, focusing on the children who are VPPs in this case, victims participating in these proceedings. Because when we speak of victims bringing to the proceedings a fuller understanding of the effects of grave crimes, the children of the direct victims are an important case in point. If we could have, please, Mr. Court Officer, slide 11 on the screen, thank you. Slide 11 gives an overview of them. 28 of the 155 victims in this case were 18 or younger at the time of the events we're concerned with. In that group, 7 were 6 years old or less when they lost their fathers to the KLA. 4 were not even born or were less than 1 year old when their family members were arrested, detained, and eventually killed. It's only natural, it's inevitable, isn't it, that these children suffered mental harm from such a loss. The youngest victims lost a parent before even being able to consciously have one. These children spent the early years of their lives in an environment filled with grief, with adults grieving, and with question marks about their father's whereabouts and fate. As noted by the mental health experts in their evidence in this case, if we could have slide 12, please. The trauma in families affects children, both at the time of the events and generations still to be born. One witness provided evidence of how her son used to ask her why the other children had fathers and who had killed his. These victims have found themselves in the adult world of harm through no fault of their own, and some still search for the truth about what happened to their fathers until this day. A number of victims who were adults at the time of the events describe the process of handing down the trauma to their children. For example, W4870 explained that growing up with a mother in a state of such stress brought on by the murder of a family member of hers, that stress had seriously harmed her children, despite the fact that they were born after the war. 4566 described enduring family trauma stemming from the fact that her husband is missing and how this affects the children, living as they must with the ongoing absence of their father and the remote hope that one day he might return. And the reference for those last two quotations, T12066 and 6959. 4371 testified how for many years he couldn't tell his children the truth about what had really happened to his father, their grandfather, how he was killed and by whom. And so his children grew up in a world where there are secrets and mysteries around the missing. And that's T15283 to 5. These examples illustrate the mechanisms through which transgenerational harm acts in the families of victims. There's also a distinct aspect of harm to being a traumatized parent, seeing and knowing that your children suffer because of events they never witnessed and in relation to which they are self-evidently blameless. This is a further consequence of the loss of loved ones for these victims and an additional source of their pain. And so it is that decisions taken many years ago to detain people and later to execute people play out to this day in the lives of those who were children, babies, or even unborn at the time, and in the lives of their parents. And that brings me to my fifth topic, the loss of home. When we deal with the loss of home, we are concentrating principally on Serbian victims who were displaced not by the conflict itself, but by the actions of members of the KLA. The starting point is the legal principle from the Basic Principles, para 19. Victims have the right of restitution, including return to one's place of residence, restoration of employment, and return of property. That is a forlorn hope in this case. It's not a possibility for the overwhelming majority of Serbian victims in this case to return to their former lives, their homes, and to resume their way of life. This group has suffered a very specific harm, and it is one that we invite the court to recognise in its judgment, applying Article 22(7). There was nothing inherent to the conflict that made it inevitable that Serb civilians had to leave. Many of them lived peaceably alongside their Albanian neighbours. In many cases, they and their ancestors had lived in this way in Kosovo for generations, some for hundreds of years. For many of them, it's fair to say that they belonged to the land just as much as it belonged to them. And to lose it has been a source of enduring grief for the families affected. It's composed of two distinct elements: the bricks and mortar of a home, and often farmlands and farm buildings that go with them. In many cases, the Serb families forced to flee had their homes destroyed at the same time or immediately after they left. Many families fled with only what they could carry and had to start again with nothing in Serbia or elsewhere. The second element of loss of home is loss of home in the sense of losing a place where they felt that they belonged. Some were clearly forced to leave. If we could have slide 13, please. Witness 1140 said, "I didn't just leave. I was expelled. It's different. It's one thing if you just leave, and it's another matter if you get expelled by someone. So I apologize, but it's an important difference." Others felt that it was simply impossible to stay. For example, witness 2749, who told us what the loss entailed. It was the end of life in the city that he had grown up in. It was the end of his job, the end of his dreams for the future. It all went, and his life took a different course, one over which he had no control. VW1 is another example. He left Kosovo after his detention by the KLA made it impossible for him to continue to live there, for reasons set out in his statement. It is obvious how his exile affects him to this day. On top of the diagnosis of PTSD that he has, and which requires regular treatment as a result of his detention, he's lost his community, his connections to his home country, his family, and his friends. For him, it amounts to losing both his past and the future that he had seen for himself before he was kidnapped. I've been calling it loss of home in order to encompass both the material and psychological impact of this harm, but I hope it's clear that the expression is also intended to express the sense of exile. That's what I'm going to say about the different types of harm. I want to conclude my submissions today, if I may, by some observations about the importance of this trial and perhaps some words about the future. We've already seen that the consequences for the victims in this case are not limited to the physical or the psychological. For some, there is the ongoing stigma of having been harmed by the KLA, which in the eyes of some in the community indicates their disloyalty. Victims speak about this as if it was a visible marker that had been placed on them. The word stain is used to describe the feeling of being given this shameful label. As in many parts of the world, Kosovo is a country in which a family's reputation is a precious thing. Witness 1743, speaking about the period after his father was killed, found that people were afraid to have anything to do with the family. Find that at P 1893.2, 8 to 9. On any objective view, you're a victim of a crime, but because of the identity and the nature of the perpetrators, people shun you. W. 1978 spoke of the way people saw him as a result of having been detained. And if we could have slide 14, please. And did the fact you were detained by the KLA affect the way people treated you after the war? Yes. The KLA took you. They didn't take you for any reason. I don't want to side with you because they'll take me tomorrow. People taken by the KLA were spies. These kinds of things. This stigmatization is a particular form of injustice. A spurious allegation may have led to your family being targeted in the first place, targeted for detention, for beating, for murder. Now, the fact that you were targeted is a passport to ostracism and exclusion. But not only do you face that injustice, in the case of many victims, there is the compounding and overarching injustice that the original perpetrators have not been held to account. And that feeling of injustice in relation to these crimes has, we suggest, been palpable in this trial. The mental health experts noted the large percentage of victims who mentioned a lack of justice as being important to them. And they also noted the adverse effect of not receiving justice on the victims. And if we could have slide 15, please. Mental health issues are worsened by ongoing social and economic stress alongside the lack of justice and institutional support. And there are a significant number of victims who this panel could identify who have not only been denied justice but have the complete opposite of institutional support, and whose mental health issues are certainly worsened by the social and economic stress brought about by their initial targeting. It's such a basic human response to want to see some accountability for a crime committed against us or those we care about. The initial injustice of the crime, compounded by the knowledge that it has been left unacknowledged, that those who are responsible for it deny it. They don't apologize. They refuse to take responsibility for what they did. It's as if the world doesn't take what happened seriously, or as if it simply doesn't care. Imagine then being one of the families in this case, living for 25 years, not only without any resolution, but without even the hope of one, until this court came into being. Witness 4781. He and his family had been the victims of terrible crimes. He spoke of how, before the KSC was established, they had given up any hope of justice. And then of how he and many others, his expression, many others, think that this court is the last hope that they have. And that's at T8431 to 2. An outcome that acknowledges the harm suffered by the victims is in itself a means of addressing that harm. Trial Panel 1 has recognised this obvious truth in its jurisprudence. And if we could have slide 16, please, on the screen. It's an extract from a decision in Case 4. The panel is of the view that acknowledgement of serious breaches of human rights and international humanitarian law is, as are reparations for the harm suffered as a result of those breaches, an important form of remedy for victims. We invite this panel to apply that same principle here. It's consistent with the jurisprudence of the European Court of Human Rights, as Trial Panel 1 demonstrates in that same decision from Case 4 at paras 21 to 28. It also accords with the experience of victims. There is some solace, some comfort in knowing that justice has been done. This trial and Your Honour's judgment is an opportunity for these and all of the victims to find some answers and some accountability for what happened to them or to their loved ones all those years ago. It is also an opportunity for these victims to have their experience of loss and pain at the hands of the KLA heard and in some cases finally acknowledged. Not only by this court, but also by the public in Kosovo and elsewhere. It's an opportunity for victims to be finally permitted to speak up for their rights, including the right to truth about what happened to those that they loved, without fear of being called an enemy. Sadly, there are still those in Kosovo who insist on claiming that no crimes were committed by the KLA and that it fought a war without moral blemish. As part of that alternative reality, efforts are made to portray the victims of the KLA who cooperate with this court as being disloyal to Kosovo. W4735, a very brave man indeed, testified here without protective measures in order that everyone would know what he had to say. He described how witnesses who testify at the KSC are falsely depicted in the Kosovo media as traitors in league with Serbia and are told they have to keep silent and have your mouth shut. That's T19415. And this contributes to the ongoing harm of the victims who, on top of all the other injustices visited upon them, are encouraged to be invisible and shamed and defamed if they decide not to do so. They are inconvenient to those who would prefer to assert that the KLA were without blame, without victims. So let's be really clear about this. The crimes and the cruelty that accompanied them, the hideous mistreatment, the brutal murder, the cynical efforts to conceal crimes, these things happened. And the denial of that fact is a cruel lie, heaped upon the cruelty of the crimes themselves. The truth about what happened to them may be hard to acknowledge because it sits uncomfortably with the narrative of the KLA fighting a pure and clean war. They caused casualties to their own civilian population and to Serb non-combatants. And it's time for that to be recognized, because that may in turn begin to bring a little more peace into the lives of the victims. Two things can be true. The KLA can have fought a war of liberation, can have done so with the overwhelming number of their members doing so in perfectly good faith. And yet the KLA members can also have committed crimes. This was exactly the point being made by W4368, whose father was killed by the KLA for, allegedly, being a collaborator. He said that he supported the KLA who do not kill Albanians, and that's at T7079. The fact that these crimes were committed by members of the KLA doesn't make it a criminal organization. It's finally time to take responsibility, not only for what many Albanians see as actions that brought the KLA glory, but also for the inglorious ones that have been the focus of this trial. No one is served by clinging to a version of the past that seeks to free one party from all wrongdoing. All that does is to demonize the victims. And so whatever the verdicts on these four men, we hope on behalf of the victims that the judgment will make it plain as day, that these 155 individuals have indeed been the victims of crimes, and that there was no justification whatsoever for what was done to them. What happens after that, we'll have to wait and see. But in our submission, that is part of the appropriate response to these crimes, and it's a part that may offer some solace to this gravely wronged group of people. I want to thank you for your attention. That is all I want to say.
Thank you, Mr. Laws. So that will finish our work for today. We will begin with the Thaci defense final statements tomorrow morning at 9 o'clock. We'll see you all then. We're adjourned until 9 tomorrow.
All rise.